A unanimous Supreme Court ruling just sent a message so clear that even anti-gun states cannot ignore it. The sight of a firearm does not give the government a free pass into your home. And if you carry, keep guns at home, or ever deal with a police welfare check, what you do not know here could cost you your rights in seconds. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a life-changing mistake when guns and police meet at your front door. Hit that button now. Here's what just happened and why this matters more than most people realize. The case was called Caniglia vs. Strom. It ended in a 9-0 decision. That means every justice agreed on the basic point, and that almost never happens in a gun-related case. The facts were messy, emotional, and honestly pretty scary. A man in Rhode Island got into an argument with his wife. During that fight, he put a handgun on the table and made a comment that alarmed her. She left for the night. The next morning, she could not reach him, so she called police and asked for a welfare check. That part is important because this did not start as a criminal case. It started as a safety check. When officers got there, they spoke with him on the porch. They believed he might be a danger to himself or others. An ambulance was called, and he agreed to go for a mental health evaluation. But here's the key detail. According to the case, he agreed only after officers said they would not take his guns. Once he left, police went inside the home and seized his firearms anyway. Now, most people hear that story and think one of two things. Either they think, well, police were just trying to help, so of course they can do that. Or they think no warrant means automatic violation, end of story. But the truth is more precise than either of those. The lower court had ruled for police using something called the community caretaking exception. In plain English, that was the idea that officers do lots of non-criminal safety work, like helping with crashes, disabled cars, and public safety situations. So the lower court basically said, if police are acting like caretakers, not detectives, maybe they can enter a home without a warrant. The Supreme Court said no, flat out no. The justices explained that a rule created for cars does not automatically apply to homes. And that difference is huge. Your car has some privacy protection, yes, but your home gets the strongest protection under the Fourth Amendment. The court said the home is where your privacy expectation is at its peak. In simple terms, the government does not get to walk in just because officers say they are helping. That is the first big takeaway. If firearms are in your home, police do not get a special blank check to enter and seize them without a warrant, just because they call it community caretaking. Now, let me explain why this matters for carry rights too, because this is where a lot of people miss the point. This was not a concealed carry permit case. It was not a case about public carry on a sidewalk. It was not a traffic stop case. But it still matters to every person who carries. Why? Because it tells courts, police, and lawmakers something very important. The presence of a gun does not erase your constitutional protections. And that matters because gun owners are often treated like the Constitution works differently for them. It does not. If you lawfully own firearms, that does not mean police can skip steps. It does not mean your home becomes a lesser place under the Fourth Amendment. And it does not mean vague safety language can replace a warrant. But here's the crazy part. The court also warned people not to overread this decision. A lot of channels made it sound like police can never enter a home when guns are involved. That is not what the court said. And if you believe that, you could make a very bad choice in a real emergency. If officers have true emergency circumstances, that can still change things. For example, if someone inside is seriously hurt, under immediate threat, or there's an urgent need to prevent serious injury, police may still be able to enter without a warrant. That emergency aid rule was not thrown out. The court specifically left that area alone. So the real rule is not police can never come in. The real rule is police cannot use a broad, made-up caretaker excuse as a shortcut around the home's privacy protections. That difference matters a lot. Imagine this hypothetical example to explain this. You are cleaning a pistol at home. A neighbor hears a loud argument and calls 911. Police arrive and want to come in to make sure everything is okay. If there is no consent, no warrant, and no clear emergency, this case is a serious warning sign for the government. They do not just get to enter because there might be a gun inside. But now, flip the facts. Imagine officers see someone through a window bleeding badly, or hear screams that sound like an act of assault. That is different. In that kind of urgent situation, emergency entry may still be lawful. See the line? That line is what this case is really about. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when police start asking questions about your gun. Subscribe so you don't miss it. Now, this is where it gets even more interesting because this case is really about 2 rights working together. Most people think gun cases are only about the Second Amendment. Can I own it? Can I carry it? Can the state ban it? Those are big questions, no doubt. But some of the biggest fights for gun owners are actually about the Fourth Amendment too. That is the rule that protects you from unreasonable searches and seizures. In other words, one amendment helps protect your right to keep and bear arms. Another helps protect your privacy and your property from government shortcuts. And in Coniglia, those two worlds collided. Here's what most people get wrong. They think if police are not investigating a crime, then the Fourth Amendment becomes weaker. The Supreme Court rejected that idea. The fact that officers are doing something for safety does not automatically mean they can ignore the normal rules. That matters for lawful carriers. Because so many police encounters with armed citizens start as safety contacts: welfare check, neighbor complaint, family dispute, suspicious person call, noise complaint, domestic argument. Those situations can turn into gun seizures fast. And when they do, the question becomes simple. Did police have consent, a warrant, or a real emergency? If not, this case gives gun owners a serious constitutional argument. But wait, there's something even more important. The court went out of its way to say homes and vehicles are different. That means if you carry in your car, do not make the mistake of thinking this case gives your vehicle the same protection as your house. It does not. Cars have always been treated differently in search law. That is one reason why this decision is about both carry rights and privacy expectations. It reminds you where your privacy is strongest and where it is not. So if you are carrying on your body in public or storing a handgun in your truck, the rules can shift. Your home is your strongest zone of privacy. Your vehicle is more exposed. The public street is different again. Let me break that down in plain English. First, inside your home, the government usually needs a warrant unless you consent or there's a real emergency. Second, around your vehicle, privacy is lower. Courts have long allowed more searches there in certain situations. Third, in public carry settings, the legal fight often becomes about reasonable suspicion, officer safety, and local carry laws. That is why one Supreme Court sentence in this case matters so much. The court basically said, what may be reasonable for a vehicle is not automatically reasonable for a home. That sounds simple, but it shuts down a very dangerous idea. If police can do something around a gun in a car, maybe they can do something similar in your house. The court said no. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Let's talk about what the decision did not do. It did not say police must always stand outside while someone inside hurts themselves. It did not strike down red flag laws across America. It did not decide every mental health seizure issue. And it did not say officers can never remove guns when a judge signs an order. That last part is huge. One of the concurring justices basically warned that future cases about red flag laws and emergency mental health holds could still raise hard questions. But those questions were not answered here, so do not make this mistake. Do not walk away saying, great, police can never take firearms without a warrant. That is too broad, and it is wrong. The smarter takeaway is this. Police cannot rely on a free-floating caretaking theory to get around the Constitution inside your home. They still need to fit within a real legal rule. And that affects how you should think during any police contact involving guns. If officers ask to come in, understand that consent matters. If you say yes, you may be giving up the very protection this case talks about. If they say they are just checking on things, that does not automatically answer the legal question. If they have a warrant, that changes the situation. If there is a true emergency, that may change it too. So, your job is not to argue case law on the porch. Your job is to stay calm, stay respectful, avoid sudden moves, and understand that the words you use can shape what happens next. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first because the law moves fast. Click subscribe. Here's the part nobody's talking about. This case also changes the emotional script that gets used against gun owners. Too often, the second a firearm enters the story, normal legal limits start to blur. Suddenly, everything becomes urgent. Everything becomes special. Everything becomes for safety. And sometimes that is true, but sometimes it becomes a shortcut. The court saw that danger. Think about how many times you have heard this line. If officers believe something bad might happen, they should be able to act. That sounds reasonable. And in real emergencies, it often is. But if you turn that into a broad rule, then any reported gun owner could lose privacy at home based on fear alone. That is the slippery slope the court refused to bless. Here is a hypothetical example. Imagine you carry every day, keep 2 pistols in a safe, and your spouse tells a friend you have been stressed out lately. The friend overreacts and calls police. Officers arrive. You are calm, you are outside. There is no active threat. No one is bleeding. No one is screaming. No judge has issued an order. Under the logic rejected in this case, police might have said, "We are just caretaking," then walked in and seized your guns. The Supreme Court said that theory by itself is not enough. That is a big deal. It means constitutional rights do not disappear when the state uses softer language. A search is still a search. A seizure is still a seizure, and your home is still your home. Now, let me give you 3 practical lessons from all this. First, know the difference between ownership rights and privacy rights. You can win one and lose the other if you're careless. Second, never assume non-criminal means no constitutional issue. Some of the biggest rights violations happen during so-called helpful encounters. Third, do not confuse your home with your truck, your porch, or the public street. Different places mean different privacy expectations. That is why smart gun owners study both carries and search law. And when I found that out, I couldn't believe how many people had been talking about this case like it was only about one man's guns. It is bigger than that. It is about whether police can create a vague safety category and use it to go around one of the oldest protections in the Bill of Rights. The court said no. That does not end every fight. It does not settle every future case. But it gives armed citizens, homeowners, and defense lawyers a strong line to point to. This information could become even more important as states keep changing gun rules and mental health procedures. Subscribe now, because in the next video, I'm breaking down what to say to police. So here's the bottom line. The Supreme Court's 9-0 decision in Cornelia v. Strom did not create a magic shield for gun owners, but it did say something powerful and clear. Police cannot use a broad community caretaking theory to enter your home and seize firearms without fitting into a real constitutional exception. If you carry, keep guns at home, or want to protect both your rights and your privacy, this is the lesson to remember. The Second Amendment matters, but so does the Fourth. And if you ignore either one, you could lose ground fast. Subscribe, stay sharp, and share this with one person who still thinks if you've done nothing wrong, you have nothing to worry about. That mindset gets people in trouble. And one last simple reminder. This video is for education only. Laws change, facts matter, and your state may have different rules. If you're dealing with a real case, talk to a qualified attorney right away.